So it is 12 o'clock, so we'll go ahead and get started. Thank you everyone for joining us today. Um, our topic for today's CLE is the Indian Child Welfare Act, and I am pleased to introduce our speaker, Shannon Smith, who is the Executive Director of the ICWA Law Center. And I'll turn it over to you now, Shannon.
Thank you. Thank you everyone for being here today. I absolutely appreciate the opportunity, and thank you all for taking time to listen. While it is still gorgeous in Minneapolis, I don't know if all of you are where you're at, but I know I think the change is happening, and as I was looking at my screen, all of a sudden the bright sun was coming through. So it's nice to have everyone here today. My name is Shannon Smith, and as Sarah indicated, I am the director at the ICWA Law Center. The ICWA Law Center is a very unique organization. We are a legal service organization. We are located in Minneapolis, but we provide representation throughout Minnesota and also provide representation in tribal jurisdictions. We have been around since 1993, and our hope is that we are providing high quality, trauma-informed, and multidisciplinary representation to American Indian families who are impacted by the child welfare system. I will be going through kind of some of the highlights of ICWA, why it's important, also talking about some of the history that that got us to the point that we're at today. I fully appreciate that that as far as the history, that it is hard history, and also that there in an hour it's not something that we can touch on in the way that it deserves, and touch on it in a way that is as meaningful as I think is really important to understand. All that being said, I think my intent is to give some context to why this matters, and hopefully inspire you all to move forward and learn more. So what we're going to start with is kind of the history lessons. And the history lessons in regards to understanding why the Indian Child Welfare Act is so important. And it's really important in regards to really understanding kind of the sovereignty of tribal nations, understanding that even prior to the creation of the United States, the British and the French entered into treaties which were agreements between governments with Native American tribes. And that really, in regards to sovereignty, is the basis of tribal sovereignty. And that was really important in regards to understanding the unique relationship between Native American tribes and the United States government. And understanding that while that relationship was very purposeful in regards to entering into agreements and entering into treaties, that it also was a relationship that had a lot of difficulties in regards to the creation of a new country, and in regards to power dynamics, and ultimately the quest for land and power. And so that is really the backdrop in regards to this relationship that continues to exist between the federal government and tribes, is a unique nation-to-nation relationship, and a relationship that is uniquely a part of kind of our history. And so I don't know if any of you are interested at all in podcasts, but there's a fabulous podcast. I'm going to give a plug in for Rebecca Nagel, who does a podcast called This Land. And she there's 2 seasons of it. And it is fabulous in regards to really understanding how this history and this land, quest for land, quest for power, and this kind of relationship that has just gone through different periods of time throughout history, has really impacted even where we're at today. Kind of jumping ahead and understanding how that has played out, there are kind of a couple of errors or a couple of policy decisions with the federal government that have really had an impact in regards to American Indian families and American Indian families in the context of their connection to both their tribal communities and in regards to their connection and the future of their children. And one of them is the boarding schools, and the other is a time that is often referred to as an adoption era. Federal policies, which included things like termination, this desire to end tribes or to eliminate tribes, periods of time and policies that were about assimilation, making sure that tribes fit into what was considered the dominant culture, have led to very purposeful and ultimately to generations of children that have their relationships with their families and their tribes have been severed. And when we think about kind of the current situation of child welfare and how government policies are used, we can look back at the boarding school and the adoption era as times where we recognize that policies and these ideas about what is best for children sometimes can be used in a sense of weapons against culture. And so ICWA, when it was passed in 1978, was really passed with the recognition that policies that had been purposeful, policies that had been deliberate in regards to separating children from their families, that ultimately they had been a failure. And ICWA was passed to shift the power of decisions about the future of American Indian children and families from states and to the tribes. And so that was something that was looked at by tribal nations as absolutely necessary in order to ensure their very existence. And when we think about schools or systems like adoption being used to separate families, I think it's really important to recognize how powerful it is to use, for example, education, right? We can all say, and I hear it in court still today, right, that education is inherently good, right? The idea that we are going to have education that will help children to learn and to be, productive members of society, that it will help them to understand, to communicate, like those are all things that often by just the very nature of education is assumed to be good. We also know, though, that because of the experiences and because of the reports and because of what we are learning about boarding schools, that education was really turned against American Indian families in a way that it was not good. Children were experiencing extensive physical abuse. They were being purposely separated from their siblings. They were punished for speaking their language. They were punished for acknowledging their religion. And ultimately, it was not just an emotional transformation that the schools were doing, they were doing a physical transformation. Hair was cut, what they wore, everything about where they came from and what they knew was they were being punished for in very physical, and oftentimes there was issues of sexual abuse going on in the schools. So we know that the experience of education was purposely being turned against, and in a way to actually remove children from their culture. And as was adoption used, we know that when the Indian Child Welfare Act was passed in 1978, that 1 in 4 American Indian children were being removed from their family and placed in white homes. And these were statistics that were coming from the University of Minnesota. We know that the intent and the purpose was very clear. It was to remove children from their families and to ensure that they had an opportunity to be cultured. The language, early language of the boarding schools was to kill the Indian to save the child. And so those kind of ideas and those kind of history are history that was not that long ago. And we know that Canada is probably ahead of us, but we know that the research or the kind of the investigation, the stories of what is coming forward in regards to boarding schools is horrific. Schools that had cemeteries, schools that had mass graves, and these ideas and this sentiment was this idea of using children, separating children from their family, separating children from their culture to create something different. And as we think about that and kind of know the background of that, that is really the kind of language that is talked about in genocide, that there was a very purposeful and forceful transferring of children with the idea that by doing that, that a culture could end, that there would be a way to separate children from their tribes. So in 1978, tribes recognized that this was going on, and tribal leaders came together and said, look, in order for us to continue to have a future, in order for our culture, our community, our people to continue to exist, something has to be different. And one of my kind of favorite pieces of ICWA being passed in 1978, and this is probably not a surprise to anyone who knows history of Minnesota, knows history of grandmas, was that it was actually grandmas that were coming together at the Minneapolis American Indian Center in Minneapolis. And they were talking about, we have to do something, and we have to do something now. This is about our babies. This is about our grandchildren. And they actually came together in Minneapolis, and they ended up in DC. And they talked about how absolutely important this was and critical in regards to the future of their people and the future of their tribes and the future of their families. So we can jump ahead, Sarah, if you want. I think one of the things, if you want to go ahead to the Federal Indian Boarding School Initiative slide, I think, yeah, right there. Thank you. So one of the things that we know, and this is just from May of 2002, we have a commitment from the government, a commitment from tribal leaders, and an acknowledgement that it's absolutely necessary to create a space of healing. That the intentional targeting and removing of American Indian children with the idea of forced assimilation was something that was incredibly traumatic. It was violent, and that we know that this existed in our country and not very long ago. We know that for many children who survived the federal Indian boarding school system, that they experienced intense trauma, and that trauma is passed on from generation to generation, and that has had a direct impact on the experience of American Indian families today. I think it's also critically important to know that I have been reminded several times by elders in the community that they truly believe that trauma is passed on from generation to generation, but they also know that healing is passed on from generation to generation. So that there's hope in the idea of recognizing, acknowledging, and then healing as people move forward and are able to, in order to work together in order to find ways and to recognize that ultimately healing will come through culture and healing will come from the truth. And so there's, a strong commitment. Minnesota is definitely a place where many leaders and advocates are gathering to make sure that that happens. They are committed to healing, they're committed to culture, and they're committed to making sure that there's an understanding of how important it is to both recognize the past and to heal. And so that is, I think, really the story of the Indian Child Welfare Act. So the why of ICWA. And Sarah's, you're welcome to move forward. I think it's just a couple of slides. So ICWA, the why of federal legislation. So ICWA is a federal law, and so it's unique in the sense that, not unique that there's a federal law, but unique in regards to the fact that it's a federal law that is that has an overlay in state court. And so the why of federal legislation, there was a recognition in 1978 that the states exercising their recognized jurisdiction over custody proceedings had failed, that they had failed often to recognize the essential tribal relations of Indian people and the culture and social standards prevailing in Indian communities and families. So that's the very why of ICWA. And it really encompassed the idea that separating Indian children from their families, from their tribal communities, had been an extreme failure. That the reality of what that had done was caused more pain, caused more heartache, and ultimately the number of American Indian children who had been removed from their families, the struggles, chemical health, mental health, the idea of being separated from the very essence of who they were, they knew. And I think another kind of common piece of the experience was often this horrendous feeling of somehow being shamed for the very person they were by someone trying to change them or trying to tell them that there was a different or a better way without really acknowledging the inherent value of who they were and their connections to their community and their family. So that's the why of the Indian Child Welfare Act. So it was passed in 1978. It was this federal law, so it was setting minimum federal standards. So saying, look, at all states have to apply this law as a minimum. It sets a floor, not a ceiling, in regards to how we can do this work. And I think it provides us with an amazing opportunity to do things in child welfare in a very different and a better way. It was passed to remedy the loss of Indian children through state court actions, and extensive testimony was taken about the devastation and trauma caused by the removal of Indian children. And that testimony, that's the testimony of the grandmas and the moms that were telling the stories of their children, of their families, and how absolutely devastating it was in order for, or when that happened. And when we look at kind of the current realities in Minnesota, we know that boarding schools, there certainly are boarding schools, but they're not boarding schools where people are forced to be at them or forcibly removed from their families. We know that adoption, continue to exist and there's protections in place. I always think that with adoption, that there is absolutely, legally a reason why adoption exists. And I always just wonder when people say, well, we need to make it easier. And I think it's an enormous and beautiful thing, but it needs to be done in the best of ways, right? It needs to be done in a way that protects everyone involved. And so ICWA allows us to do that. I think the reality though in Minnesota is that we have changes, right? Things have happened in a good way in regards to education, in regards to adoption. But we have these devastating numbers that continue to exist, that Indian children are 20 times or more likely to be removed from their families through the child welfare system. So there's an enormous amount of work that continues to be needed. We have to respond. We have to do this work in a better and a different way. And the statistics are coming from the Minnesota Department of Human Services. They're coming from counties. So we know that the reality is that our response to American Indian families in the child welfare system has not been a healing response up to now. They're continuing to experience the devastation of being removed. So the why of ICWA continues to exist. ICWA was a federal response, and as I talked about, it really is about setting a minimum federal floor and really inspiring states to do even better. In regards to the Indian Child Welfare Act, there was a lot of legal parameters that were recognized as causing the devastation, things that had not been in place that American Indian families had experienced prior to the passage of ICWA. Things like notice, not being noticed of proceedings involving their own children or children in their family. Tribes not receiving notice of what was going on. They were not told until later that they no longer had custody or decision-making authority over their own children. They didn't always know where their children were. There's stories of children being removed from one boarding school and then being moved across the country to purposely, separate them from siblings. There was information in regards to children being taken from the hospital with very little explanation as to what was going to happen or what their legal rights were. There was very little judicial oversight, no tribal involvement, and oftentimes there was threats or this idea that if American Indian families did not comply with the requests of the state in regards to their children, that very basic essentials would be withheld from them. There was ideas that in order to consent to adoption or to the relinquishment of rights after a baby was born, that it could be done immediately after birth, and it could be done at a time when maybe mom was under medication, or it could be done in a way where she was not given an opportunity to see her baby. So the legislative history of ICWA was, there was extensive information in regards to how the legal process, how the courts, how government agencies were working in a way that did not uphold the voice of American Indian families and didn't uphold the voice or the sovereignty of tribes. In regards to the policy, congressional policy was very clear that it was not working. And so things had to be done in a different way. And ultimately, the idea was that the policy of the nation had to be to protect the best interests of Indian children and to promote stability and security of Indian tribes and families. And this was going to be done by the minimum federal standards. I think that this is a really, for any of you who are practicing in family law, any of you who are going to be practicing or do practice in juvenile courts, this is maybe one of the most, I think, difficult things for the court to make decisions about, and the best interest. I have had the opportunity and the honor to represent moms and dads and other family members. A lot of my work has been with moms for over 25 years. And the idea of best interest is something that I think is a real struggle, and I use it in court still because that's court language. That's what we, that's what we use. But it's really, I think we need to pause and kind of really think about what this means and how we really look at this, because I think one of the things in regards to best interest is that it is a place in the system where our biases, whether implicit or explicit biases, are very, very difficult to really navigate as we're talking about children that the children that are not our own, right? So like I think about this in like some really just really practical ways, and culture ways. And one that I think about is I had the opportunity, I have 4 children, and had the opportunity to raise my children in South Minneapolis, and our neighbors, who had children about the same age, had were from Italy, or the father was, and so they were and they had lived there. They knew the culture, and as our children were, 3 or 4, and talking about at the park about kind of how our night had been the night before. And I remember one time, my neighbor, who was a dear friend, um, was complaining or tired or just, complaining that she hadn't gotten any sleep. And I was like, well, that's a bummer, kind of what's going on. And she's like, well, her 4-year-old had been moving around and, rolling around all the time. And I was like, well, why wasn't he in his own bed? And she looked at me like I was like, well, why would he be in his own bed? And we had a conversation, and she's, was a school principal. She had all the, kind of all the context of, both raising our children in houses next door to each other in South Minneapolis, and recognizing that we had some very different ideas about things as how a child is comforted or how they sleep. And she explained to me that in Italy, like, you would not leave a baby crying. I think one of the big things when I had young kids was like, you would let them cry because otherwise you might spoil a baby. And she's like looking at me like, you would never spoil a baby. Like, they need to know that you're there. They need to know they're comforted, and they need to know that they are safe all the time. And if they need to, come into your bed at night because that's where they're safe and can sleep, that's what you do. That's kind of who you are as a parent. And I had some very different ideas, but I think as we're talking about that, and as we think about that, things as simple as how you sleep all can go into these ideas of best interest. And I think sometimes in the court system, and maybe a lot of times in the court system, we all go into court in a family court setting, in a juvenile court setting, and we have these ideas about what is in the best interest of a child. When in reality, we can be having these conversations and we can be using the same language, but mean completely different ideas, or be representing completely different thoughts in regards to how we care for our children. And I think we all know that, and we have some factors that help us kind of look into specifics, but I think it's still a place where, as we move forward and we're thinking about this work, how important it is to really take into consideration how families, how they look at that and how they live that and how they know that. And recognizing that that is language that we use with this idea that it means something that we can all understand. But I think the reality is the factors that go into that, even if we have, factors written out in statute that we need to consider, can look very different for different families. And something just to acknowledge and be a part of. And I think that is really critical in regards to the Indian Child Welfare Act. I had a tribal attorney I had an opportunity to work with one time, and she, described it from a tribal perspective, that as they are looking at the best interest of an Indian child, that they felt like, so in this particular case, the judge had asked for a photo of the child, who was, I think, about 4 at the time. And it was in the context of a report, and she, the tribal attorney, said, there was no objection, to the child's picture in this case being a part of the record. But she really challenged us all to make sure that we were not looking at that snapshot in time as the reality of best interest, that we really had to look at this child as a child who was going to continue to grow. And so that instead of a photo, really what we would need was, in a sense, like a video, right, of time moving forward. And what that child looks like at 4 may be very comfortable in the home, being kept safe, the very things that foster parents, were their role. They were serving their role incredibly well. But the concern from the tribal perspective was, what is that going to look like when that child is 6? Or what's that child going to look like when they're 13 and there's ceremonies and things that child's family, that child's community is very important to them? And what will that look like if they're separated from that? And how would that look different from maybe a snapshot in time to the reality of that child as that child grows into the teenage years and grows into adulthood? When we look at the Indian Child Welfare Act from a parent representation perspective, and certainly this is not just, I understand that that's the perspective that I'm coming from, but when we look at the Indian Child Welfare Act as far as kind of where does the force come from, and why is the Indian Child Welfare Act so powerful, and why, as the Casey Family Programs has indicated, is it really the gold standard of child welfare practice? And when we're looking at that and we're thinking about that, Section 1912 of the Indian Child Welfare Act is really critical. Section 1912, and Sarah, you can go ahead and move forward. Section 1912, and I know this is a lot of words on one page, and it really is not intended to, hopefully you all will receive the PowerPoint, but if not, you can look at Section 1912 and you can read through it. But I just wanted to highlight, this is the section that has all kinds of substance in regards to the practical reality of Indian child welfare practice in state courts today. So in Minnesota, when I practice in Hennepin County, Ramsey County, wherever I'm at, this is 1912 from a kind of an everyday hearing practical experience is critically important to me. So 1912 gives us the section about notice, that parents get notice, that Indian custodians get notice, that the tribe gets notice. So that's critically important. It gives us a section in regards to appointment. In Minnesota, we do a relatively good job, maybe a better job now. There's been some recent legislative changes, but making sure that parents have representation in child welfare cases, so CHIPS cases and termination of parental rights cases. But in ICWA cases, that is something that there is a federal right to. If parents cannot afford counsel and the court determines this, they've had a right to counsel since 1978. So again, gold standard of how we can do child welfare cases in the best way possible. Section C, one of my favorites as an attorney, we get reports, we get the documents. So really a discovery, an opportunity, a right to see what the evidence is, to see what a county has or a third party has in regards to what is going on in a case. And again, in Minnesota, I think we do a really exceptional job in regards to discovery, but certainly something that, as far as a federal minimum standard. Section D is active efforts. I am going to come back to that because that may be my favorite thing. But certainly as far as Casey family programs, recognizing that if we are going to respond to families in crisis, that active efforts are absolutely something that all families deserve and all families should have a right to. But ICWA there's a federal statute saying that that is true. And then for foster care placements, there needs to also be an opportunity for a qualified expert witness, which is someone who can talk about and give insight in regards to that child's connection to their tribal community, to their culture, and how important that is. And then for termination of parental rights, again, qualified expert witness. This is another area that I think ICWA truly is a gold standard, is that in a termination of parental rights proceeding for a case that the Indian Child Welfare Act applies, the legal standard for the termination is beyond a reasonable doubt. For a non-ICWA case, for example, in Minnesota, the standard is clear and convincing evidence. And I think that it's really important as we kind of think about that, the enormity of what is happening when a termination of parental rights is occurring in state court. For an American Indian child, but for any child, that ultimately that decision means that that child is losing their connection to their family of origin forever, right? Like a termination of parental rights is one of the most extreme things the law can do. And so in that sense, it's something that should be a very, if that decision is being made, we want to make sure that we're getting it right. And certainly elevating the standard to beyond a reasonable doubt is a way that, in the context of the legal system, could be helpful. The gold standard is something that really gives us an opportunity to look at the child welfare system. And I'm going to go back to the active efforts piece. So in the context of a child welfare case, the idea, and there's all kinds of different reasons why a case may come into the child welfare system. And we know for American Indian families in the state that oftentimes when a family is coming to the attention of a system in crisis, that oftentimes it is for situations of struggling with chemical health, struggling with mental health, struggling with the experiencing violence. And active efforts gives us an opportunity to respond to families in a really meaningful way. And I think that's true for certainly in the context and in what ICWA requires, but it's true for all families that somehow we have to do better in regards to how we respond to issues of chemical health in the state, and how we respond to issues of mental health, and how we can provide a meaningful response. I think one thing that I think about with active efforts, and this is something that an elder in the community brought to my attention, for any of you who have experienced or know or have been a part of a child welfare case, you may know that a case plan is really kind of a critical document that gives the parents, or is intended to give the parents, a roadmap to address the issues that may put their children at risk of being in foster care, or if the children are in foster care, really a roadmap in regards to how the children, how they can work towards having the children come home. And ultimately, within the context of child welfare, the idea and the sense and the policy is that if children can safely be with their parents, that's where they need to be, right? Like that's the place where they are going to be best cared for. That's going to be the place that's in their best interest if they can be safe, well cared for, and parents are healthy. And in the context of the child welfare system, the case plan often becomes kind of the piece that we talk about a lot. And in a non-ICWA case, we talk about reasonable efforts. And in an ICWA case, we talk about active efforts. How do we respond? How do we provide efforts in order to allow this family to move forward? How do we allow this family to heal? And this is all coming, kind of the active efforts language is all coming from section 1912D. And with the active efforts, so going back to the kind of the piece that the elder told me that has stuck with me is when we're doing these case plans, for any of you who have seen a case plan, it's often kind of written in a way where we're asking families to do a lot, right? We're asking them to get a comprehensive assessment to assess whether or not they need chemical dependency treatment. We're asking them to get a mental health assessment in order to determine kind of what the next steps. We're asking them to provide documentation of sobriety, so to go do a UA. We're asking them to comply with visitation supervision facility. We're asking them to call the social worker. We're asking them, to respond to the request. And she, as I was kind of going through, at the time she was working at our office, and we were really talking about a case plan for one very young mom, and the mom in this case was very very present at our office, very present in the community, but she was really struggling in order to kind of take the next step as far as going to some of these places or getting started. And part of it was she just didn't know what the next step was. And we were kind of talking, and I was explaining to her, well, you need to do this, you need to do that. And that's when the elder stopped me, and she's like, wait a minute. She's like, as kind of a very innate human response to people who are in crisis, people that are hurting, people that are grieving. If I was going to respond to a family member, if I was going to respond to a neighbor, a relative, when they were in a place of grief, I would not ask them to do more. I would instead, as she pointed out to me very rightfully, like you would ask, like, what can I do for you, right? Can I bring you a meal? Can I take care of your children? Can I go for a walk with you? Can I bring you anything? What can I do? Can I give you a ride? And as she was talking about, she's like, that's what active efforts needs to be. That's how we need to respond to families. Instead of asking them in a place where, at a time when they are in crisis, or a time often when they're grieving that they are no longer able to put their child to bed, grieving that they are no longer with their child, that instead of asking more of them, we have to get to a place where we know how to meaningfully respond so that they then are in a place where they can actually work on their case plan in a way that makes sense and is meaningful. And so I think as we're talking about active efforts, when we're talking about the child welfare system, certainly in ICWA cases, because we know the number of children who experience foster care is incredibly high, and the disparities are horrific in Minnesota. But we also know that this idea of being active and responding to people in a meaningful way is something that really the child welfare system as a whole we can do and we can learn from. And really that is the essence of why the Indian Child Welfare Act is the gold standard of child welfare practice. All of that leading up to a recent US Supreme Court decision. And my sense and my hope is that understanding history, understanding kind of some of the implications of how the Indian Child Welfare Act plays out in courts, every single day in Minnesota, that it has a meaning, that it's purposeful still, that it really shapes the way that we can think about how we respond to families in crisis, how we can elevate their voice and provide a path for healing. That my sense is that all of that is needed to understand why the Indian Child Welfare Act is so critically important, not just as a statute that responded in 1978, but a statute that is living today, meaningful, purposeful in regards to how we do this work. And recognizing that, I think, is incredibly important to understand the context of a recent US Supreme Court decision. And again, my plug for This Land, the second season of This Land. So the first is about a Supreme Court decision, McGirt. It's a decision in regards to kind of a jurisdictional decision, but was really about land and sovereignty. That was the first season of This Land, and the importance of land in regards to the relationship between tribal people, indigenous people, and their land, and how powerful and meaningful that is. But in the second season of This Land, that is connected to what is happening in regards to the Indian Child Welfare Act and litigation to challenge the constitutionality and the recent U.S. Supreme Court decision. So you get both. You get this whole sense of like history and importance, and she does, I think, a really, really remarkable job connecting it to where we're at today in regards to continued challenges of the constitutionality of the Indian Child Welfare Act. And so the U.S. Supreme Court decision was a decision that came out in June of 2023, so it is very new. And it was a decision that is incredibly, I think, important in regards to child welfare, but certainly more important in regards to the recognition of tribal sovereignty, a recognition of culture, a recognition in regards to how important it is for American Indian children to have a right to be connected to their families and to their tribal communities. The U.S. Supreme Court decision, the background is complicated. And there is a connection in regards to Minnesota. And so one of the things, I'm sorry, I just got a little tickle in my throat. One of the things, just full disclosure, we did write an amicus brief that really outlines the story of why we were involved, why the Indian Child Welfare Law Center was involved. And certainly that is something I'm happy to share, is also available. But we wrote an amicus brief on behalf, supporting the constitutionality of ICWA on behalf of Robin Bradshaw. Some background leading up to the U.S. Supreme Court decision. There was, in 2017, so the case took some time, 3 individual families in 3 states, including Texas, sued the United States government. And what they wanted, they were suing the government, indicating that ICWA was unconstitutional. And one of the families was named Brackeen, and that's how we got the case name. Ultimately, the case was renamed Holland v. Brackeen when Deb Haaland was appointed the Secretary of Interior. The case was, the lower case decisions came out of Texas. And so kind of an interesting, I guess, just procedural process, in light of the fact that at the same time this procedural process was going on, the case was moving forward in Texas, there was litigation going on in Hennepin County. And so just to give you some context in regards to kind of how removed the Texas court was from the reality of at least one of the named parties. And ultimately, there was an incredible amount of local and national support for the Indian Child Welfare Act. And the 497 tribes, all 11 Minnesota tribes, tribal and Indian organizations, members of Congress, Senator Klobuchar, all signed on in regards to recognizing the importance of upholding the constitutionality of ICWA. And because of how the case had moved forward in Texas, it was akin to like a summary judgment motion. So as the facts were moving forward in Texas, they were stipulated. And so the case in Minnesota, and certainly our amicus brief kind of talks about some of this, was a different story than the factual the facts that were moving up in Texas. And so that was one of the frustrations, one of the hurts in regards to the process. The Texas court, when they found that parts of ICWA were unconstitutional, wrote an extremely long over 300-page decision. But in that decision, they kind of cite to the facts of cases. And so just for example, in the Minnesota proceeding, they indicate that in the Minnesota case that grandma wasn't licensable, that the guardian ad litem did not support the grandma being able to care for her grandchild, and also indicated that the adoption was not final. The reality was that by the time grandma knew that that her case, or the prospective adoptive parents in the case were included in the Texas litigation, the guardian ad litem supported grandma. The child had been with grandma, and significantly, the adoption had been finalized. And so there's a lot of frustration and hurt in regards to the constitutionality of this law that was so important to this family and so important to this grandma being challenged, and really outlining facts that were simply not true at the time that the decision came out. She had not been involved in that litigation at all, and because of the procedural place that it was in, those facts continued to move forward in the Texas court. In regards to, so a lot of frustration, right, in regards to the idea that the very court that had opportunity to hold an evidentiary hearing over several days, decisions were made, witnesses and evidence, and ultimately a finalization of an adoption. None of that was considered in the context of the Texas decision. Ultimately, the Supreme Court decides that they will accept a granted cert of the, and in November of 2022, the Supreme Court heard oral arguments in regards to the Holland v. Brackeen case. In June of 2023, the decision, in a 7-2 decision, the Supreme Court upheld the constitutionality of the Indian Child Welfare Act. The things that had been challenged in the Texas court was whether or not Congress had the authority to enact ICWA, whether or not the placement preferences violated the Equal Protection Clause, and certain provisions of ICWA violated the anti-commandeering doctrine. And that was really kind of the basis of the challenge. And the U.S. Supreme Court, in their decision, in the 7-2 decision that was written by Justice Amy Coney Barrett, declared that ICWA was constitutional. The oral arguments were long, they were intense. I had the opportunity to be in DC during that time. And it was a very fascinating, I guess, just in regards to just the history and trying to understand the complexity of tribal sovereignty, and recognizing the importance of that unique relationship between a tribe and their citizens, recognizing that relationship was a political, the importance of, that political relationship between a tribe and their citizens. And so a lot of questions, a lot of just history that went into trying to understand why it was so important and why the unique relationship between the federal government and tribes really mattered in regards to this kind of legislation. Ultimately, the decision was made that Congress did have the power and the authority to enact ICWA. This came under the Indian Commerce Clause. It came over plenary power and the adoption of powers in the U.S. Constitution. They also recognized the trust relationship between the federal government and Indian people. In regards to the anti-commandeering claim, it was ultimately decided that it was not anti-commandeering and that the federal government was acting within their powers. The court did not address the equal protection specific to the placement preferences, and And so that's where we're at in as far as the decision. It was a decision that I think is significant, incredibly important. I think in the context of the decision and understanding how important, kind of going back to the very beginning that we started with, is really was Justice Gorsuch's historical kind of concurrence in regards to the decision. And I think that is kind of where I want to end today with what he had to say. And I think it is incredibly powerful. And this is directly from his decision. Often Native American tribes have come to this court seeking justice, only to leave with bowed heads and empty hands. But that is not because the court has no justice to offer them. Our Constitution reserves for tribes a place, an enduring place in the structure of American life. It promises them sovereignty for as long as they wish to keep it. And it secures the promises by divesting states of authority over Indian affairs and by giving the federal government certain significant but limited and enumerated powers aimed at building a lasting peace. In adopting the Indian Child Welfare Act, Congress exercised that lawful authority to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. All of that is keeping with the Constitution's original design. Well, thank you all for being here today. I truly appreciate it. I do know in the presentation I think Sarah added to the chat that you will have access to both the recording and the PowerPoint. My contact information is, I think, on the very first slide. And so if anyone has any questions or anything, that you would like to talk through, please feel free to reach out anytime. We always love to hear from people, love to kind of hear what's going on. And certainly if we can provide any assistance, we are happy to do our best to do that. So thank you all so much.
Thank you, everybody, for attending. I don't see any questions in the chat. As Shannon mentioned, we will make this available online. And so we'll go ahead and end the session here. Thank you, everyone, for attending today. And thank you, Shannon.
Yeah, thank you.